Your Lordships, may I make a mention?
You want to mention?
No, madam. Seek an adjournment, I'll wait for it.
Yes, which matter?
One matter, bank has issued a notice, 8-day notice. There is urgency because they want to take possession of the property. But that matter may be taken up tomorrow. We are ready to settle the matter. We have said also in the affidavit of. It may be taken up tomorrow.
Fourth will do, fourth.
Well,
Fourth or tomorrow?
tomorrow.
Tomorrow.
All right, tomorrow.
My Lord, I filed a writ appeal which is pending. A writ appeal is pending before your Lordships on the.
It is that urgent?
Lord,
It is that urgent?
Lord, it is urgent because they have issued notice yesterday.
Yes.
My Lord, the respondents are on the strength of the learned single judge's order. They've gone to the regional labor commissioner and trying to enforce it. The writ appeal may be rendered infructuous. The matter is posted before the RLC tomorrow. Therefore, it may be taken up. There is some urgency in the matter. May I request an early list?
What is the order passed by learned single judge?
Remitting the matter back to the RLC for, because it was first closed by the RLC against the order for seeking permission to prosecute the management.
Not tomorrow, no,
Next week early. my Lord.
next, 7th.
My lords. My lords, these are two appeals, these are two MFAs under section 37, my lords. There's some urgency, my property is languishing. There's an order by the Honorable City Civil Court refusing or restraining me from alienating the property, my lord. But there's a genuine concern. I've been trying to develop this property for the last 12 years.
Not before 15th November.
My lords, next week, my lord, at least. I was requesting for tomorrow at least, but in that instance, my lord, there's some genuine urgency.
You can seek time there, yes. 15th November.
Forest land is being encroached. The learned single, this is a contempt petition of the learned single judge had directed for non-interference with the property. Yet they define the order with the learned single judge and interfering with my property.
Let it come in due course. You remove the office of it, it will be posted.
It's all complied with my lordship.
Then there is no point in
My lordship,
mentioning.
date will be allotted, my lord.
Date will be allotted then 22nd November. Yes,
First contempt petition, my lord, the interim order has been.
The Lordship of PIL of 2021 and 2022, Your Lordship, the Lordship in the first matter is regarding the encroachment that has happened in the 5 major lakes in the Dharwad city, Your Lordship. We have made several representations. There are no steps taken by the state, Your Lordship. Your Lordship, the second memo what I'm moving is regarding the procurement centers, Your Lordship. It is only open for a limited purpose of time. We are seeking, we have made representation for the benefit of the farmers so that it may be open for the whole year, Your Lordship.
no urgency.
Your Lordship, any date may be given.
Date then 3rd November, 3rd December. So if you wait, then it will come earlier. If you seek date by filing memo, it may come as per our choice. To choose your option. You want to wait for regular listing or you want a date from us?
Yeah, second week of November.
Second week of November and 25th November.
This is a writ appeal. During the pendency of the petition, there was an interim order. Now, during vacation, the matter was listed and it was directed to this after vacation. The matter is before commercial court on 4th of November. The only date is given in the-
15th November.
Contempt petition, my lord. It's only contempt.
3rd December.
Each of the interim order, my lord.
Third.
Put up the construction.
3rd December.
We put it there, go on with the construction, my lord, instead of the interim order is there, not to put up the construction. Reaching the order day by day, my lord. Construction is over, my lord, that order will become instruction.
Go before learn single judge. Interim
Yes,
order.
sir, in the interim order has been granted.
Or like 5th. Yes,
Adjournment.
yes, madam.
Section to fix the boundaries, my lord. The authority has not complied the single judge order.
12th November.
Before that, my lord. November.
Pardon?
November.
5th November. What is that urgency? So protection regarding what? Encroachment. Police will provide protection if you make an application. Again, you make an. Or 6th November.
Serial number 39. I am for the fourth respondent. The reply is ready. I will file it during the course of the day.
Serial number?
39. The reply is ready. I will file it during the course of the day. I have already intimated the counsel for the petition.
11th November.
Please.
Serial number 92, my lord. Filing a memo to withdraw the petition.
Withdrawal, learned advocate, Mr. Swami Gowda.
Yes, sir.
For the complainant files memo dated so and so dated 29/10/24, seeking to withdraw the present contempt proceedings dismissed as withdrawn. Memo is taken on record, be dismissed as withdrawn.
56, my lord. 56, my lord. I for the respondent one in the matter.
Yes,
Therefore, 2 weeks' time to file statement of objections.
the
I've
petition,
informed the petitioner, appellant counsel.
then it will go to 3rd December.
Please.
My lord, serial number 21, my lord. 21, my lord.
21.
Advocate on record is not keeping well.
Hmm?
Advocate on record is not keeping, my lord, next week, any date, my lord. 21,
20th November,
please.
Serial number 17, madam. From the
70,
17, madam.
17,
He pays for a week's accommodation, sir. Senior is not feeling well, much.
21st November.
Serial number 87, my lords. Coming
17.
for non-compliance. 2 weeks time may be granted.
87 is non-compliance of office.
Yes, please, madam.
3 weeks are granted to comply with the office observations. Once the office observations are removed, the writ petition may be listed.
Please. My lordship, serial number 65.
60.
Complainant, senior is out of station, madam. Kindly a date may be given.
So when shall we keep 25th of November?
Any mention through VC, sir? Thank you, permission. Contempt matters, seal number 1. Mr. Subramania Bhatyam.
I appeal to the complainant, my lord. My lord, order of the learned single judges at Annexure A, which was passed on 27th May 2024, my lord. Therein, the direction to the petitioner was to submit a representation to the authorities and respondent shall consider it within 8 weeks. Subsequently, on 6/6, this.
Notice, 3rd December.
Seal number 2.
Yes.
Mr. Adi Narayanappa.
Complaint implemented the withdrawal. Even after lapse of 15 years, they have not paid the amount. Quite of quota.
3rd December notice.
Sir, PL matters, seal number 3. Mr. Sumant L. Bharadwaj.
My lords, appear for respondent number 2 to 4 months. Undertaking to file wakalat, my lords. By course of the day, we'll be filing our wakalat minutes.
Let us see, what is it about? You are for respondent.
Respondent number 2 to 4 months.
What is, you are appearing?
My lordship, it's a AL with respect to the misappropriation by the government doctor, my lordship. The fourth respondent, Dr. Savita. She is given a contact with her own son by using this power.
Ms. Nilofer purpose from one state of Karnataka and learned area of Mr.
Syed Shahrukh for SH Prashant.
Correspond 2 to 4. Full stop. This petitioner is filed. This petition is filed, styling it the public interest petition. The petitioner claims to be running an organization in the name and style of Poukar Mikra, Pourkr Mikra, Avalambithara, Okutta, page 4 per. The petitioner is stated to be studied up to 10 standard and claims public credited person. Full stop. The case put forth paragraph is that respondent BB from Bangalore Mahanagar Palika integrated BBMP has without following procedure obtained the services of respondent 4 in awarding the contract and sanctioning the bill for January 2022 in favor of first respondent. The case put forth is that the respondent Bangalore Mahanagar Palika and BBMP has sanctioned bill. That is the grievance, bill. Bill is sanctioned.
Salary is not given to the doctors, Malaship. She is given the outsourcing she has taken a service from the outsourcing authorities without having tender and not released the salary to those doctors. She is misusing the power.
Is the case put forth by the petitioner that respondent 4 herein, who is working as medical officer in the Mahanagar Palika, Bangalore Mahanagar Palika, BBMP, is awarded contract without following procedure. It is the further allegation that the said respondent has approved the bill of salary in irregular manner and that the doctors are not paid. Doctors and the pharmaceutical staff are not paid the salary. With such grievance paragraph, the prayer is made by the petitioner that representation dated 12/6/23 and 29/3/23 given 29/3/23 and 12/6/23 given to respondent 1 state will be directed to be decided. First of, in filing the public interest petition paragraph, the petitioner appears to be busybody, 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 and that he has filed a petition to general to be countenanced. The allegation doesn't have any substance here from the record. The only prayer paragraph is for deciding the representation submitted to the respondents. While dismissing the meritless public interest petition, it is observed that it will be permissible for the petitioner to pursue the representations made to the authorities. The authorities shall expeditiously consider the same and decide in accordance with law, preferably within 10 weeks. Petition is disposed of, as not entertained.
Obliged.
Petition is dismissed as above.
Yes. Seal number 4, Mr. Kiran B.
What is the?
Water.
Huh?
Given representation for 2 to 4 million. Earlier, there was the encroachment, they removed again the encroachment. Water canal.
Who has encroached?
One, they just, some of the village. Representation to the two to- okay. So they have to give some strict, strictness against the encroachers, otherwise this will be continuing. Due to that, my lord, the overflow of the lake, my lord, that is going on abutting lands due to this encroachment. The block shed water canal which the water comes from out of lake.
The prayer heard learned advocate, so on, so on, so forth. Sorry, for the petitioner and learned additional advocate, government advocate, Srimati Neelo Bharat for the respondents, upon service of copy of the petition in advance. The present is a public interest petition. Present is a petition styled as public interest petition. The the 4 petitioners claim that they are the permanent residents of Thrunasi, Thrunasi, Thrunasi village, Masthi, MSTHI, Masthi Obli, Mallur Taluka, and that they are public spirited persons. Also, the prayers advance in this public petition is as under bracketed portion, page 14, to direct. Masthi police, direct Masthi police. And the case of the paragraph, after quoting the prayer, the case of the petitioner could be gathered in nutshell from the averments made in paragraph 11 of the petition, comma, extracted herein, and page 10 to 11, bracketed portion, full stop. The grievance thus is that this number 4 has failed to take action. This number 4.
When was the inspection done, sir?
The Panchayat Development Officer, Thrunasi Gram Panchayat, Thrunasi Village, Masti Obli, has failed to take action against the illegal encroachment on the neighboring landlords, against the neighboring landlords,
That is.
despite receipt of representation dated 5/2/2014, 2024. The petitioner wants that the encroachment from water canal from Raja Kaluvu, KLU, Raja Kaluve land, bearing survey number 120, measuring 10 mutas, situated at Runasi village, is required to be removed in light of the representations dated 5/2/24. Full stop. The subject matter is in the domain of the respondent authorities, paragraph. paragraph. Subject matter is in the domain of the respondent authorities to be looked into and to be looked into by considering the representation of petitioner, which is stated to have been made and has remained undecided. Full stop. In the totality of facts and circumstances, the present public interest petition could be entertained only to the extent by directing respondent 2 to 4 to act through their competent authority to consider the representations made by the petitioner regarding encroachment, arrive at effectual finding after necessary inquiry, etc., and take appropriate decision oblique action as may be required in accordance with law, without expressing an opinion, paragraph on the merits, the present petition is disposed of.
Time bound, 30 days, within 30 days.
Preferably within 12 weeks from today.
This is seal number 5 to Govind Raj K.
Petitioner in this case, my lord. In this case, my lord, on 26/6, this honorable court directed to form the team and fresh inquiry and inspection and report to be submitted, my lord. Team was formed by the respondent government and filed memo on 19/7/2024.
My lord, the report is ready. My lord, I'll file it in the office. My lord may have this next week, my lord.
11. Since learned additional government advocate Srimati Nilofar Akbar will be filing replies 10 to 11th November.
This is seal number 6. Please, Neha Nagraj. Seal number 6.
Live. Fast.
IPR for respondent number 3 members.
Okay, for the petition. Petition,
You have to take instructions.
My lord, I'll pray for some time, my lord, because an authority has to be
20th.
constituted.
In order to enable learned additional government advocate Srimati Nilofar Akbar to take instructions, further time is granted 10 to 22nd of November.
Obliged.
Grateful. So green bench matters, seal number 7. Avinash Gowda.
Challenge the order of the revisional authority, rejecting our request for deemed extension under Rule 8A.
So notice returnable on 14th November.
Serial number 8, is similar to yesterday's matter, which your lordship has posted on 6th, could be called on the 6th. Serial number 8.
6th.
Yes, then serial number 8. Great.
Seal number 9. Here the L.M. Chidanandaya.
Order annexure G. Rejecting all the applications. Include the application of the petitioner in the subject matter of the petition.
You are challenging annexure.
Annexure A minute.
What is it?
That the application filed by the petitioner is rejected on the ground that the petitioner has violated 3G at one particular point of time, and therefore my application is become invalid. Like 3G says that I should carry out the export of the finished products, and there is a percentage mentioned 3C. A notice was issued earlier, and I replied saying that I have complied. That issue came to be closed by the very same secretary earlier. Now, on the basis of the alleged violation of Rule 3G, let the secretary rejects my application on the ground that he may again violate Rule 3G if the lease is granted. That's the only reasoning given. That reasoning your lordships will get at page 39.
Oh, like notice returnable. We'll go to 19th November.
Please. Seal number 10. Vaishali Hegde.
Where is it?
The matter in which
Respond.
regarding.
Yes, where is it?
This is same matter, which, yes. Where is the advocate general?
My lord, he's coming, my lord. My lord, maybe passed over. my lord.
Then sixth of.
There's some
Six of-
urgency. Now they have constituted one more committee, which is meeting on.
My lord, then.
Yes.
No, meeting notice. We have received one more notice now. Now they have constituted one more committee to go into the issue of this royalty differentiation. Here it was about 754 crores.
792.
792, all. Then it was brought down, my lords, to about
57.
257 crores.
So what is the dues they are claiming?
My lords, now the last notice they are claimed to 257 crores,
No.
which.
This
Hello.
correct. What my learned from this slide, original demand was 792 crores, my lords.
That's
792.
Then subsequently, my lords, demand came down to 257.6 crores. Then last time, your lordships, I said we can amicably discuss and sort the matter issue out, my lords. That is why we issued this notice to, there are two different, it is quite high. So that we have issued a notice, they are appearing tomorrow, my lords, to sort out what should be the actual amount.
Actually, they both, of course, we'll attend the meeting, my lords, we have no issue.
Appearing before?
The committee constituted.
committee,
I just
my lords.
place the copy of the notice.
I'm giving a copy. In order to resolve the issue, my lords, it is not thing. In fact, I had made a statement before your lordships, my lords, we'll try and resolve the issue with the page 18, maybe kindly, see, last document, page 18, my lord, last page. Karan, it's okay. You tell. In furtherance of preliminary meeting of the committee appointed by to examine matter pertaining royalty demand notice issued by so-and-so, so-and-so, so-and-so. And the report of the committee as per the reference government order dated 18th is required to be submitted to the government within 15 days.
So committee is
Meeting tomorrow, they have called us for the first time.
Your lordship, may kindly see the page 7, my lords.
Okay.
Page 7. This is a government order page 9 may be relevant, my lords. Page 9,
Second para in the order,
second paragraph, my lords.
from there.
Page 9, second paragraph. After the proceedings of the Director of Mines dated 10th May 2022 pertain to areas of royalties due to Associated Cement Corporation Limited, demand notice dated 10/4/2024 and dated 2/9/2024 was issued, and the demand notice were challenged by Associated Cement Corporation at various stages. In the case of Associated Cement Corporation, the demand raised for payment of areas is based on clinker ratio. In view of the variation of amounts in the demand notice dated 10/4/2024 and 2/9/2024, and there arises a necessity to ascertain whether aforesaid demands are conforming to the parameters followed for raising demand in other cases. Therefore, in respect of the matter concerning Associated Cement Corporation Limited, it is considered necessary to constitute a high-level committee headed by a senior officer of the state government to verify and confirm the amount towards royalty areas payable by the state government for the period 1995, 1996 to 2023. Hence, the state government had decided to appoint a high-level committee comprising of technical director, Department of Mines, so and so and so. The committee constitutes. So therefore, my lord, this is being decided by the committee, my lords, because there's a variation in the amount. The only thing what my learned friend is trying to tell now, my lords, their mine is stopped as on.
Stopped from the time I filed the rate. We are only saying, my lords, we'll work the mine.
7th August 2024.
Oh. We'll at least work the mines and the unit, my lords. We'll deposit the royalties, subject to the calculation.
Let the committee decide.
You will deposit the royalty amount.
Royalty, my lords, we had sent a DD for about 49 crores, my lords. They returned it. 33, 49. They had returned it back to us. So we'll deposit again. The DD is with us. That we'll give. That is for the
49 crores.
40, about 49 crores, which includes interest also. 33 crores is. And my lords,
What 49 crores is too less compared to the demand.
No, my lords, that earlier demand of 257 crores, the principal amount was only 68 crores. The rest is towards interest. In both the notices, it's only towards interest. What we are, my lords, this 49 crores, what we have said is.
The revision proceedings are pending.
My lords,
Revision is.
revision is still pending on that issue, but if the committee solves, everything will get solved. But in the meanwhile, let us permit.
We pass some order today.
We can work the mine subject to, my lords, the committee is finding, at least because today, my lords, my unit is closed. Cement unit is closed.
That will see, but first you let the committee have its.
Yes, my lords, committee will appear tomorrow, but at least if we start, my lords, there are several employees, my lord, more than 1,000 employees.
Where is the order of the revision?
There is no closure order as on date.
Going by the revisional authority or annexure
A, my lords, is only to sort out the issue. ILMS is locked.
Where is the order sorting out this?
My lords, there is no order to stop my mining.
No. There was some observation to resolve.
Annexure A, page 56, my lords.
Page
56, para 4.
Last paragraph, my lord. Can I read it, my lord? Considering the above submission, the representatives, my lord, para 4.
That's because my ILMS is locked.
This is the order, this is the revision authority, full stop. So this petition is directed against this.
We have come against this, and also where they are directing us, my lords, one issue is they are asking us to.
Third learned senior advocate, Mr. Phanindra, with learned advocate so and so for the petitioner, and learned Advocate General Mr. Sushikaran Sesti, with learned additional Advocate General Mr.
Shanti Bhushan.
That's DSG. He is
Revisional authority.
Deputy Solicitor General.
Deputy Solicitor General Mr. Shanti Bhushan, as well as learned additional government advocate, assisted by additional learned additional government Neelofer Akbar. Full stop. The writ petition of is the present writ petition is directed against the present writ petition arises out of order dated 31/7/24 passed by the Joint Secretary and the Revision Authority. Wherever dispute involved is essentially in respect of the liability of the petitioner.
Demand towards arrears of royalty.
You are a mining unit.
My lords, arrears of royalty in mining.
Petitioner mining unit to pay the royalty amount. It was stated in course of the submissions that original demand raised by the authorities against the petitioner was 792 crores. You are engaged in what?
Limestone, was mining of.
My lords, limestone for cement.
So, mining unit engaged in the excavation of limestone. The original demand, it was stated in course of the submissions as raised by the authorities was 792 crores, which in the last demand notice was shown to be 257.6 crores. Learned advocate, senior advocate for the petitioner submitted that the total amount is only 68 crores and the rest are the amount towards interest and penalty. Be as it may. The order of the paragraph, Revision Authority, inter-alia, observed in paragraph 4, expecting that the issue will be resolved by the parties. Court paragraph 4, page 56. Considering se start hota hai or within a week. Full stop. Notice was issued. The petition.
No, notice issued now.
Notice.
Not issued now. Your Lordship, you mentioned that we had appeared. my lord.
Petition.
No, notice was
the
issued.
Petition came up for consideration for this court
Order sheet.
earlier and thereafter today. Today, comma, a development was shown to have been taken place by learned dialogue of the respondent state. A memo dated 29/10/24 was produced on record,
Our memo there.
along with which copy of the proceedings
Page 7, my lord.
Of the government,
Comment,
Page
page 7.
government order constituting committee.
government of Karnataka date is not there.
My lord, sir, your lordship's
Page
get at
9,
page
my lord.
9.
Page 9, middle, my lord, 18th October 2024.
18/10/24 was produced.
Constituting committee.
It indicated that the subject matter of demand of royalty claimed, payable, claimed from and payable by the petitioner corporation. Calicut. Was considered, by the petitioner, was considered. And in that regard, the issue of formation of high-level committee to verify the demand was addressed. Full stop. Paragraph. The minutes of the meeting, from extracting the relevant part, reads there and page 9. Just
It's an extra.
financial reconciliation. Paragraph. Paragraph after quoting. As per government order dated 18/10/24, a high-level committee consisting of the managing director of the, what is BMRCL?
Bangalore Metro Rail Corporation Limited.
Bangalore Metro Rail Corporation Limited. Under the chairmanship of a high-level committee, under the chairmanship of the managing director, Bangalore Metro Rail Corporation Limited. Comprising of additional 5 members, whom include the representative from Indian Bureau of Mines, former Assistant General Manager, Karnataka State Finance Corporation, former Deputy Director, Department of Mines and Geology, former Deputy Director, Duplicate Legal, Upper Deputy Director Plan, then Deputy Director Legal, from Department of Mines and Geology, and Superintendent, Department of Mines and Geology, who would be the convener member, has been constituted. The committee is directed to go into, committee would be going into the following aspects. Then page 10, 11, 1 to 8. Green. The order itself indicates the proceedings from order, proceedings and the order indicates that the committee shall provide opportunity to the company concerned, that's the petitioner hearing, as well as to the officers of the department to express their views and opinion. Full stop. The development of constitution of committee is indeed in furtherance of the observations of the regional authority, which expected that the problem would be resolved by holding joint meeting of the representative of the revisionist desk petitioner hearing and the state government and the office of the state government. Full stop.
Page
So
18,
stated.
page 18.
Notice is.
Notice, Manoj, meeting is tomorrow.
That time, yes.
I'm sorry for interrupting, I thought.
The document in the memo further, the memo contains further document of the nature of notice, which reflects that the meeting of the aforesaid committee constituted is scheduled to take place on 30/10/24. That is tomorrow. Full stop. In the aforesaid view, not in the aforesaid view, learned senior advocate, Mr. Learned senior advocate for the petitioner submitted and stated that the petitioner is ready to deposit 49 lakh, 49 crores.
My lord, the last date he said 100 and something.
Lords,
I will let him not.
correct,
take
correct.
back.
No, I will not.
How much?
Lords, we had deposited 40 crores, which they have sent back. Last time I had my lords, I had made a submission that 101 crores will deposit. That's 68 crores of principal plus 40 what we had already sent a DD and which they have returned it back. Now, my lord, since 68, of course, if he wants to say, I'll deposit the 101 crore.
110 crores.
110, 68,
My lord,
40.
what-
Okay,
My lord,
okay. My lord, my learned friend wants to,
Doesn't matter.
No, no,
it
what
doesn't
my-
matter.
What my learned,
There is your figure.
so that is his, can I state mine? My lord? He's saying 110. That's why I gave the three figures are there. My lord. There is 792, there is 257, there is 110, what my learned. Or, I'm just trying to,
Yeah.
and
This towards, not out, not fully, not
I
fully.
both don't, my lord, I'm not. So therefore, my lord, anywhere between, at least not 792, 257 and 110, my lord, I leave it to your lordship to decide and,
Lords,
because that would be, I'm leaving it to your lordship.
today, my lords, they are subject to correction. I am only saying, my lords, 33 crores was the demand. We
No, no.
sent one.
Sorry.
33, no, I'm not disputing yours. 33 crores DD was towards principal. But the rest of about 14 crores and odd was towards interest. So what we said,
We are really not adjudicating.
Lord,
We are only asking reasonable amount without prejudice to anybody's right.
without prejudice, my lords, just give me a moment, my lords. Lords, we are saying my instructions are. Hundred and one crores will deposit without dispute immediately. 101 crores, they are ready to deposit.
110, 101.
My lords, they are saying 68, I know, my lords.
As on
Then
to-
committee would do what?
My lord, your lordship noted that 8 points, my lord.
110, my lords.
Your
I don't
lordship,
want 110 crores,
As long, there are,
110.
my lord, we
110.
decide the matter within next 10 days, my lords. That is first, like, as on today, there is no mining lease executed, my lord. What your lordships are, as on today, there is no mining lease. The point
What
is
the committee will be doing now?
to that at point, page number 12, my lord, your lordship may kindly say, the determine the royalty that is payable
Arrears
by
of
them.
royalty.
Arrears of royalty from 1995, 1996 to 22, 23.
Lords, we had paid the royalty. It's not that we had not paid. There is a difference of calculation. So we are saying without prejudice, we'll deposit 110 crores. Let me start mining. If they want to resolve, my lords, today I have employees, my clinker unit is closed because I have a captive cement plant inside the mining lease. I'm only saying 110 crores, we are going before the committee. If it gets resolved, my lords.
Learned,
Lords, I'm saying,
Let them say, Manoj, your lordship may decide the interim arrangement. Within 10 days, Manoj, let them, these are the 8 points, Manoj, which you pointed out. Let them, apart from the amount that they have to do, ultimately what is determined, let them say within such and such a period, they'll deposit what is determined by the committee, Manoj.
Lords,
No, interim arrange, whatever your lordship.
interim
board-
arrangement, my lords, at least if I start mining,
No, that is okay. Second is, once
state
this
also
is,
will get money.
once this is decided within 10 days or 12 days, my lords, let them deposit that balance amount within a reasonable period, what your lordships may fix, my lords.
We are not even sure how it will go.
How-
No, my lord. 110 lords, I'm ready to deposit without prejudice. $257. Only arrears.
No, license will be executed only on payment of the royalty amount. Yeah. As of
Lords,
today.
according to us, there is a license. They have extended. Today, they are saying supplementary lease deed, I will execute only if you have a no due certificate. Now, no due certificate, this issue is going on. According to us, actually, under law, there is no need for a lease deed to be executed because it's a deemed extension. There is a government order. Now, the Supreme Court says if there is a deemed extension, there is no need for a supplement. But I will not get into it if we are still willing, if they sort out this issue. I am not at fault.
Within 10 days, we'll resolve this issue, my lords. Only thing.
I have a government order extending my lease.
Let them, we'll board on the amount, my lord. Within 10 days, we'll resolve this issue. In fact, on the first day when.
Deposit work ಮಾಡಕ್ಕೂ ಬಿಡಲ್ಲ ಅಂದ್ರೆ ಏನು?
ಯಾವ್ದ್ರಲ್ಲಿ?
Mining ಶುರು ಮಾಡಬೇಡ ಅಂದ್ರೆ ಏನು? Why am I giving the deposit? Government order, you have extended the period.
Page.
Government order says it's a subject. Please see 4. You say something, please see 4. No, it should be
Extended subject to.
30, my lords, the Supreme Court says. It is there. What they are saying is I have to execute a supplementary lease deed. Yes, this has arisen because of this.
I'm not arguing on facts, my lords. Yeah, page 79 is 31st March 3030, but we have to execute a supplementary lease deed. The requirement of supplementary lease deed is payment of royalty, my lords. Now the dispute is regarding what is the amount of payment of royalties before your lawsuits, my lords. Now that's the only issue. Once that issue is resolved, we'll execute a supplementary lease deed till 31st March 2030, my lords.
2030.
Sorry, I'm stand corrected, 31st March
2030.
2030. So therefore, my lord, the question is, the committee has been constituted. At least they should obey by the decision and give an undertaking that the amount which has been finally decided after issuing notice, after hearing them, they'll have to pay that amount, my lord, so that we can execute a supplementary lease deed.
Lords,
That
I
would
am
be
only
fair, my
saying,
lords.
no, fairness is one. Lords, we are saying, in fact, there is no requirement of a supplementary lease deed. But if you still want, I will do it. But the Supreme Court's judgment is if there is an extension, there is no need. At least for the present.
I'm sorry, my lords.
We want to just start the mining, my lords. At least let me start mining. The unit will start, even they will get. Yes, my lords, I understand. Today, my lords, if I have to pay money and then keep quiet, my lords, it doesn't make.
Just write it and give.
Mining. Two or 3 days.
Then they can pay more also.
Very, I mean, Bernadette. No, we will do it. There is already a DD, the rest amount.
Well, they've already got the DD, I believe.
This amount is there already. Please.
Whom should they pay?
Amount is to be deferred.
To the Department of Mines and Geology.
Department of Mines and Deputy Director, already some DDs.
State of.
Please.
2 weeks. 2 weeks we can complete.
Agata.
Yes, my lord.
3 weeks.
After approval of the government, after approval of the government.
That's, that's.
My lords, then I'll have no legal recourse. Suppose, my lords, they come. That, my lords, we'll come back, my lords. Suppose they determine some 900 or 800.
No, no.
Then, my lords, again, I will be from, it's been. I will. Because we have already deposited now.
With the state, my lords, we'll keep it in, let them deposit the money, we'll keep it in escrow separately, my lords.
My lords, we'll come back once they determine. Suppose if I am agreeable, I'll pay the amount itself. Suppose if a condition is put that I have to deposit entire money, my
No,
lords.
I'll suggest one more thing. Let them deposit the entire amount, we'll keep it in escrow, we'll execute the supplementary lease to them after that, my lords.
My
We'll
worry
execute
is
the
that
supplementary lease deed after that, my lords.
because I'll have legal. My lords, we'll come back by that time. Your lordships can put us on terms. Otherwise, my lords, my legal windows will be closed once they determine something else now. But if I have to, my lords, that's before the revision of. Or I will come back, my lords, then your lordships can put us on terms. Let us at least see. That window may be open. If your lordship now.
But we can't have the cake and eat it.
No, not cake and eat it too. I'm only saying today.
My lords, what would be fair is, let them deposit, we'll keep it in an escrow account, my lords. And we'll execute a supplementary lease deed in their favor also. And one more thing, my lords, they can, just one sentence.
Sorry.
They can challenge it also, then we'll come before your lordships, my lords. Then your lordship may decide.
I'm only saying.
Then your lordship may decide that, my lords.
Yes, my lord. Today I am depositing 50%. Suppose if they, my lords, today it is 257 crores. Suppose they come to 300 crores or something. I'm only giving a rough estimate. Then about out of 257, now I have deposited 125. It should not happen that they ask me to deposit another 300 crores. I have already given that. As of now.
That is subject to the decision of the committee, my lords. Because there are two orders, my lords. One is, we don't know, my lords.
That's my worry.
No, my lord, I'll just say on facts. There's a demand of 792, which is challenge in revision. There's a demand of 257. That is the problem. That is why this committee has been constituted to arrive to hear them. And after hearing them, whatever the material placed by them, we'll take a call. My lord, they're in our state, my lords. We don't want to harass them. Whatever and there's a rule 49, my lords, speak.
Come back on that. New decision only will come back. Let them put it. That 257 also came through a committee. May I suggest this, my lords? After they take a decision, let it be posted here. Your lordships can put us on terms. That your lordships can observe you. That my lords. Lords. Now, my lord, let them consider. We'll anyway come back, my lords, immediately. If it comes down from 257 also, I am okay. But today, they themselves voluntarily said 794 is wrong. Their committee has come to a conclusion, it is 257. Now there is a third committee. I am not having any difficulty going before the committee. I'm only saying now with this, my lords, will come back in 4 weeks. So by the time they take the decision, will come back to the court.
We are trying to be, our intent is not to close, not to harm. Let them. Execute supplementary.
He has no.
The supplementary list it. List date. If it may arise.
Against that. And Lords, I understood. I got your lordships. Your lordships have given an indication that this should be done. Without it, Lords, I understand. Lords, Lords, that much of experience I have before Lords.
First week of.
Lords. Very good.
Okay, Manoj, Your Worship may say in the Manoj, in the Your Worship may in the peculiar facts and circumstances of this case, Your Worship may say, because as an because other mine owners also nobody will deposit.
The interim.
Just if Your Worship may mention that, so that Manoj, it may not be. Keeping in view of the facts and circumstances, just it's in the middle of, I'm grateful to you. Please, I'm good.
Obligement.
Great. Please. First week of December, Manoj.
Or second week,
Second week of December. In fact, Manoj, whatever the report, we'll hear them, we'll satisfy them, we'll show them, it's under Rule 49 what we are calculating, Manoj. Principal amount is not in dispute, it's only the calculation of the interest amount. So we'll sit across and we'll show them why we are calculating, let them say why our calculation is wrong.
That they are willing to cooperate, my lords,
That's all. There's no rocket science in this.
Till 1 week later, because if they don't take a decision, again we'll come back and subject to my lords. Please.
Then please.
Yes. This is number 11. Ravindra Gajana,
Please, my lords. The petitioner has filed a query lease application, produced annexure D at page number 46. The learned government advocate may take notice for the. Please, my lords.
Obliged.
This is number 12. That's why surely.
Not. Here also not petitioner had moved an application seeking a quarrying license, which initially was rejected. I went in revision petition. Revision petition was allowed, directed the competent authority to execute the lease, which they are not complied. Therefore, Lord, I am before your lordships seeking implementation of the order passed by the edition. Now that is the order at annexure J.
Lord, page 82.
Relevant portion.
Lord, fifth line, competent authority to take action in the matter after obtaining permission from the government.
relevant portion of the order is at page number 81.
My lord, the order of the, my lord, competent, the revision authority, I'm sorry, my lord, page 81, my lord, the second last sentence. It is further directed directed the competent authority to take appropriate steps as per the provisions of KMMC rules 1994 and also as per the guidelines. There's a direction. If my lord could give me some time, my lord, I will verify and submit to my lord as to what has happened pursuant to.
Please.
My lord, whether this direction has been complied with or not, and if it is
Please.
not complied, why so much time? My lord may grant me any time. Any time, my lord, 16th or 18th. Okay.
This. Bill number 13. Sanjeev BL.
Public.
Number 14. Karthikeyan BS.
Request for 2 weeks time, my lords. I'll comply with the office objections, please. Great.
My request for lordship to fix a date in this matter.
Second. This is number 15 to Onkar KB.
Appeal for appellant. In this case, my lord, challenging the order passed by the honorable single judge, my lord. Challenging my transfer order. My lord, in this case, my lord, the first respondent was working as a AWE, my lord, at Mysore, my lord. Meanwhile, my lord, he was suspended on the ground that because of dereliction of duty, my lord. He challenged the same before Honorable High Court, my lord. While the petition was pending, sixth respondent was transferred to that place. My lord, when the sixth respondent was also suspended, my lord, and the Department of Inquiry was initiated because the trap was conducted by Lokayukta, my lord. I was appointed, my lord, on 12/1/2024 to that place on the health ground, my lord. I was having minor heart attack, and on medical grounds, I was transferred to that place, my lord. Meanwhile, my lord, 18/11/2023, this the honorable single judge, my lord, had passed the order allowing the repetition challenging the suspension order by the first respondent, my lord. And, sorry, my lord.
My lords, I appear for the caveator respondent.
2-3, yes, ma'am.
Your lordship, I request, I am taking notice for R1, R2 to R5, your lordship.
My lords, if I may just make a small submissions, my lords. The order, my lords, whereby suspension was quashed was challenged before your lordships and, my lords, by the corporation. The, my lords, suspension order.
We are not issuing notice. We are
Please,
keeping it on if you come physically so that we can better appreciate.
Please,
Yes,
Your lordship, I am appellant in another connected matter, your lordship. I require 2 weeks time to comply the
Next.
office of.
Number 16. NR Nayak. 16.
16, nobody is there, 3rd November.
Beg to appear for appellant, my
Third,
lord.
yes.
167 days delay, my lord.
Pardon?
Delay, there is a delay in
Notice
filing.
returnable on 10th December.
Please.
Yes, next.
17 urgent. Till number 18 to Kevin Narasimhan for appellant. My lord, praying weeks time, my lord, praying for weeks time, my lord.
3rd December.
Seal number 19.
My lords, I appear for the appellant, my lord. There is a
Yes,
delay of
Notice
31
written on
days.
11th December, delay of 31 days. Next. 20,
Seal number 20.
I appeal for the appellant, my lord.
delay,
Delay is
11th December.
great.
21 adjourned. Seal number 22. 22.
Delay,
My
12th
lord.
December. Notice written ever 12th December. Next.
My lord, there is one concern. My lord, R5 to R9 address are not correct. If I may be.
That part in person states that the addresses of some of the respondent is not correct. Therefore, learned part in person shall supply the correct address within 10 days. Put upon 11th,
My lord.
12th November for that purpose and for further orders on that to be passed on that day. Next.
My lord.
Number 23.
Correct address was not given. I may be permitted to serve the council and file an acknowledgement.
No, that is not possible. Next.
23 government appeal.
23 notice,
Three state
notice written around 12th December.
After filing of the contempt petition, they have filed this.
So we are issuing notice in your delay application. Next.
Seal number
Right, maybe.
24.
Contempt, they have filed contempt petition. Thereafter, they file this appeal.
So contempt
In fact,
matter
in
shall
the
be
earlier
listed.
proceedings, the second. order
Contempt petition shall
application,
be listed together.
like, it has been already been listed together, my lord.
So again, we are directing to list together. What is wrong in it?
There is almost 10 years, my lord, they are unable to do Kodi and Durasti work. I am suffering every day, my lord. It's
What
more
do
than
you-
10 years, my lord.
What do you want? But without the condoning delay, how can it be heard?
But delay may be condoned, it may be heard, my lord.
How much?
Lord.
11 days. 3 days, acha.
We
Heard
are
learned
11 days, my lord.
adjudicated verdict,
11
delay
days
is
delay.
condoned. Application is allowed. Writ appeal may be listed on 12th of November.
Obliged.
Along with this,
Please.
along with contempt.
It's already tagged on, my lord. Contempt is already tagged. ಅವ್ರ ಹೆಸರು ತೋಡಿ ಅವ್ರು ಯಾರು ಅಪೇರ್ ಆಗ್ತಾರೆ ಎಲ್ಲರಿಗೂ ಅಪೇರ್ ಆಗ್ತೀರಾ 1 to 4
Cross-examination.
Cross-examination, my lord.
Yes.
This is cross-examination of PW1, plaintiff's witness. And just read this, my lord. If I'm asked when the defendant handed over the possession of the suit schedule premises to the plaintiffs, I say defendant never handed over possession. Witness volunteers in December 22. The court changed. And at that time, apprehending that if we wait for court order, we will go bankrupt, we took over the possession. This is the conduct of the landlord. And my lord, now the landlord has been rewarded, my lord, with arrears of rent. And these arrears, my lord, are for the COVID period. Immediately, my lord, when the COVID strikes, I send a notice invoking force majeure.
We will admit the appeal. What can be?
My lords may only protect me with some stay, my lord, on the judgment. My lords may put me to terms also, because 2.5 crores liability of arrears of rent has been determined against.
So money decree.
Money decree. Yes, my lord, because possession was taken over, what remained was money. And my lords may put me to terms.
Deposit game.
Make some concession, my lords may consider.
But then you are not in possession now.
I'm no longer in possession.
So
now it's only about money.
What protection can be granted?
My lord, only in terms that they don't execute this.
Execution.
Only to that. And my lords may consider only one other fact. My contention was that in the force majeure period, under the lease, I am not required to pay rent. I send a notice. For 1.5 years, he accepts my notice and keeps quiet. I continue in
Required to
possession.
pay rent, why?
My lord,
Not required to pay rent.
that was my contention.
Why?
My lord, because owing to COVID, my lord, I relied on the force majeure
COVID.
clause. My lords may consider one more fact, my lord. He accepts, receives my notice of force majeure. Had he responded to my notice and said, no, you are my tenant, you have to pay rent, I disagree with your contention on force majeure, probably it would have been sorted out, my lord. 1.5 years, he holds my notice and waits.
So this rent is in respect of the period covering the COVID period.
COVID period.
Total.
COVID.
Completely. What is that period?
My lord,
From?
I will just point out. My lords may give me one. My lord, the lease deed was registered in February 2020, my lord. Thereafter, COVID struck during the rent-free period, my lord. From 22nd March 2020, I am claiming the COVID period.
Now possession is with whom? Third party.
I'm sorry, my lord.
Possession of the premises is with whom?
Now with the third party.
Third party.
Even that he confirms.
Already
And my lord,
again rented.
my lord,
Again rented.
he is getting rent there. And my lords may also consider this. All my items worth 50
Used
lakhs
for
are
what?
still there.
Used for which purpose?
My lord,
Premises was used for what purpose?
my lord, I was running a co-living space in the nature of a PG, paying guests, my lord, co-living for young professionals.
Commercial Court, Bangalore. In
Commercial was 1736 of 22.
OS number 1736 of 2023. Paragraph, the suit came to be decreed. The plaintiff was this respondent herein was entitled to, was declared to be entitled to, was held entitled to recover from the defendant sum of rupees 2,33,18,888 toward the arrears of rent from June 2020 till the date of termination of tenants, as well as this main profit is determined.
I'm sorry, Miller?
In profit is determined. Damages
Not determined. Not determined.
the date of termination.
Yes.
Till November 2022. The court refused the prayer for grant of interest. In course of his submissions, paragraph, learned advocate for the appellant stated that the defendant was evicted from the premises forcibly during the proceedings of the suit. In this regard, he invited attention of the court to the cross-examination.
Page 151.
Page
151.
Cross-examination of the original plaintiff. In particular, paragraph 10, in which it is admitted that the defendant was evicted by the plaintiff, even when the trial of the suit was under progress. Learned advocate for the appellant would orally submit that now the possession of premises is not with the appellant, and that the plaintiff has given out the same to the third party, be as it may. Paragraph. It was further submitted that the appellant was running a PG hostel.
PG hostel.
Postgraduate hostel for the students. In the premises he took on rent from the plaintiff. It is his submission that the disputed amount of rent pertains to the period when the affairs in the society were at a standstill in view of the COVID-19 pandemic. Learned advocate prayed for stay of the judgment and decree insofar as it entitles the plaintiff to recover the aforesaid amount of rupees 2,33,18,888. Paragraph. The part of the decree which entitles the original plaintiff to recover the amount is in the nature of money decree. Therefore, it cannot be stayed in its entirety without condition. Normally, it is right that the court would require the party seeking stay of money decree to deposit the entire amount, entire decretal amount. However, in the present case, the defense raised is that the amount of rent pertained to the COVID-19 period. Since the appellant was stated to be running PG hostel in the premises, it is reasonable to conclude that the students would not have stayed during the COVID period in the premises. Full stop. Taking into account paragraph. The aspects where the appellant dependent is already evicted from the premises and the amount is relatable to the COVID disputed, and then the rent amount is relatable to the COVID-19 period, which was the period when the affairs in the society were at a standstill, comma, the judgment and degree of learners, following order is passed, comma, the appeal is admitted. It may be listed for final hearing in the week beginning from in the second week of February 2025. Full stop. By way of ad interim leave, comma, there shall be stay of impugned judgment and decree insofar as it entitles the petitioner to recover the amount of rupees 2,33,18,888 on condition that the petitioner deposits 1.25 crores within 10 weeks from today. The petitioner shall abide by the final outcome of the petition.
Notice, notice.
It is not, once it is admitted or notice of admission will not go to, it will automatically.
If I may please, your lordship.
Appeal is admitted, let that notice of admission of the bill shall go to the respondent.
If I may please, your lordship, so CL number 25, I was just held up in court hall number 4, but I, however,
Well,
came
you can't
running, your
mention.
lordships.
When the board is going on, you can't mention. Yes, next.
Great.
Mr. Vivekananda TP.
That's on 29/7/2000.
He is yet to come up before the honorable board. Lordship may proceed. RPA revision petition has been, review petition has been filed.
All right. 3rd November, 3rd December.
After lordship's directing the personal appearance of the accused, it appears the review petition is filed after 2.5 years. There is no justification for
Direction to appear or in person.
Your lordships have directed for appearance of the,
He is present before the honorable.
and they said the assistant executive engineer is the authorized officer to determine the compensation.
Now you are planning to file review appeal.
My lord, what has happened, my lord, that actually that road is not needed by us. We have not used it also.
The following order was passed on 29/7/24 in the present contempt petition. And quote the order. It was as big as. Full stop. Today when the petition comes up for consideration. Full stop. A stand is taken on behalf of the respondent PBMC that a review petition is filed in respect of the order under contempt. Full stop. After, as the stand is highly unreasonable in wake of the order passed as above. Not only that, the order passed by only single judge was
23rd August
passed
2000.
as big as on 23rd August 2022. It pertains to determination of the compensation payable to the complainant petitioner. Full stop. In view of above, it is provided that unless the appropriate orders are obtained by the respondent BBMC in its review petition on or before 15th November, comma, the respondent shall be exposed to aggravated form of contempt. This public. That is over to 20th November. To be listed at 2:30.
Engineer is present before the honorable.
We are not concerned. The engineer is present.
Yes, present.
So we'll take them to the
On the last week, there was a direction that he should be present.
straight to prison for non-compliance of the order. It is not the matter of laughing, Mr.
No, my
Counsel.
lord.
We are too lenient not to become, we can't be too lenient.
My lord, what has happened, my lord, may I mention two?
that particular road which.
You are sitting tight for 2 years?
Yes, sir. That is what, sorry, my lord.
No, let us see if he is present. Let us recall the order.
My lord, I'm sorry, my lord.
When you are going to determine the compensation, tell us. We are recalling the order.
My lord,
We will not
50
permit you to pursue your review.
Lord, I'm sorry, my lord.
You are not serious in your approach.
No, my lord, I'm.
For what the officer is present.
Sorry, my lord, I'm sorry.
We don't want the officers present for the sake of his presence. This
No,
is
my
what
lord.
we wanted
Just-
a compliance of the direction.
Lord, I informed the honorable court, my lord, that's all, my lord.
No, now we are asking you why he is present.
No,
Without-
I don't,
We are asking you, Mr. Counsel, why he is present without compliance?
no, he should be present, my lord, in
Then
fact, my
comply
lord.
it when you are going to comply with. Come on 5th and comply with the order.
Sir, your lordship make.
No.
That order, my lord, I'll see.
No, we are withdrawing that order.
By 15th, your lordship make.
No. Come on 7th and comply with the order. Or take the order in
Yes,
the.
my lord, I should not be.
So order will remain, but instead of 15th in September, 15th November, it will be 7th November. Get it, whatever you want to do. Mention before the learner single judge or review petition.
Sorry, my lord,
We are also sorry because we are
My
noticing.
lord, I'm sorry, my lord, I do not know, my lord. If I hurt my lord, I'm.
No, we are not hurt. We are hurt by the conduct. We are never hurt. We have no emotions, no
My
feelings.
lord,
We are court
no
of law,
point
Mr.
of
Counsel.
time, my lord, I do not want to.
We are court of law. We don't have any feeling. We have no emotions. We only look at the order which is passed in 2022. And now you are coming with the officer who is not complying with the order, despite our direction. And projecting a filing of the review petition. We will not allow that. Yes, same order, 7th November.
So complaints in contempt matters, number 28, SB Mukanappa.
The complainant in this. Like the today itself, I received the affidavit, but my lord, the payment made through the contractor, not from the corporation.
Who appears?
I appear.
What is to be done?
My lord, and this what has happened. My lord. They were working as outsourced employees. My lord. Now, my lord, the payment what was ordered, my lord, has been paid through the outsourcing agency. And the total payment has been paid, my lord, by check.
But then whom was to be paid?
My lord, can you see the affidavit along with the payment made?
Salary to the petitioner for the period from April 13 to
The Shri Lakshmi Enterprise.
14 salary. 10 years back. So you paid to the outsourcing agent.
Outsourced.
How can you raise a difference?
My lord,
But
that is
my-
under question, my lord, it has been challenged, my lord, the others are also there, about 6,000 of them, my lord, have been regularized, similarly placed to employees. Gangmen have been regularized, my lord, these are the other persons, my lord, about 2,000 are working.
That
My
is-
lord, today
You have
itself,
right, but then you have to
at
comply
present
with
also,
it.
my lord, they have received salary from the corporation, not through the like.
You did not point out to the learner single judge.
The my lord,
Did not point out, did not appear, my lord. I have not appeared.
the honorable learner single judge, my lord, the directed the respondent, the
You
accused
file your-
corporation.
File your compliance.
Yes, please.
File it. 20th November. We are making it on 15th November only.
But I'm extremely
But you
sorry, my
do
lord,
that.
at no point of time, my lord, I have not.
15th November. You do it, get the order in.
Sorry, my lord, if I.
You trigger the anger on our part.
Idu 20th November. It's number 29. TP Vivekananda.
Here for the respondent.
20.
Lordship may kindly grant, the writ appeal is filed on the original order. Notices issued, Lord, on the condonation of the delay, Lord, and stay matters to come up, Lord.
22nd of November.
Please, and let the writ appeal also be tagged with the writ.
To be listed with.
Please.
Writ appeal ఉంది.
1340 of 2021.
21.
Please,
Pardon?
writ appeal 1340 of 2021 it is.
All to be listed with writ appeal.
Number 30. The Nataraj Ballar.
What is it about?
The complaints affidavit has been filed.
Compliance affidavit is filed.
Please,
What are the directions?
That's to consider their representation, my lords, for Lebanese sketch, my lords. Lords, Lebanese sketch is issued only in respect of private patta land. But here is a land in the name of the father of the complainant, which is granted, and Podi and Durasti has not been conducted. Therefore, we have referred the matter to the Lebanese construction of the records before the missing committee, my lords.
So it is complied with.
Please.
My lord, they have my documents were sought from me for preparation of the Lebanese sketch. I have submitted it and filed my application in the year 2015. Lord, now the records are missing in the office of the authorities and they are not issuing me the Lebanese sketch. Now they say that they have placed it before the missing committee, district level missing committee. A time frame may be fixed, my lord. Otherwise, I cannot even, because there is a partition between the family members of the original grantee. They can't enjoy the property. My lord, without Lebanese sketch, my lord, there cannot be partition at all between the legal heirs of the original grantee. That is my difficulty. My application is of the year 2015. They say that it has been placed.
Order of Learned Single Judge dated 15th March 2024. Contain the following direction, which are brought under the contempt jurisdiction by filing this petition. Then quote paragraph 4. Extracting from paragraph 4, then quote paragraph 4, accordingly, page 12 per this paragraph. In response to the notice by this court, the respondent has filed compliance affidavit in which it is inter-alia stated that
Para 5 may be seen, my lord. They say that they have issued an endorsement.
Original record in relation to the land made in favor of the father of the complainant is not available. Some of the documents such as manual RTCs, RTC, small s RTCs, encroachment, regularization register and Darkhas register are available in the office. It was stated. A circular dated 20th/6/2016 of the state government was referred to. And it was further mentioned that the available documents came to be placed before the district level missing committee for reconstruction. Proposal for full stop. A proposal for preparing 11E sketch shall be forwarded, stated the deponent, to the competent authority, subject to outcome of the missing committee report and Podi and Durasti. In this regard, the endorsement dated 18/10/24 is passed and the above facts as mentioned in the endorsement. It is accordingly paragraph submitted that the directions of Learned Single Judge have been complied with by acting upon the subject matter, as above. Paragraph looking to the directions issued by Learned Single Judge in paragraph 4 quoted above, it could not be said that any of the respondents have committed any contempt, much less willful contempt of the directions. Full stop. The authority is acted upon towards compliance of the direction as above. The contempt proceedings are required to be closed. Paragraph at this stage, learned advocate for the petitioner will submit that the time frame may be fixed for completion of the proceedings before the committee. Full stop. Since in the original direction, Learned Single Judge has required the consideration of the applications of the petitioner within 2 months, it is reasonable to provide that the entire proceedings before the committee shall be completed within 2 months from today. Full stop. In the event the decision is reversed to the petitioner, petitioner shall be at liberty to challenge the same in independent proceedings in accordance with law and on its own merits. The present proceedings are disposed of accordingly.
Seal number 31, Mr. Ravindra Gajanan Pulle.
Please, my lords.
It can go to some other date.
And the difficulties, my lords, for the last 1 year, my stone crusher unit as well as.
8th will take up, 8th of November. You got it.
So, but the difficulties, the forest department has misled and there is no gazette notification. On the last occasion, my lords were pleased to observe a typographical error mentioned by the DCF,
We'll
which has
consider.
now been corrected, my lords. Till the issue is resolved, I may be allowed to operate the query because since.
We'll consider on 8th. Will issue notice then, notice returnable.
Notice everything, it has been heard on 2-3 occasions, my lords. And now they have filed, learned the government advocate has filed.
It was heard before this bench.
Yes, my lord.
My lord had heard the matter. My lord, 2 government notifications have been issued wherein, my lord, 2 items of land have been declared as village forest and fodder forest. My lord, permission had been granted to the petitioners, my lord, to quarry. Thereafter, it is found that that area comes within the fodder forest. My lord, I filed the 2 notifications, but there was typographical error. So my lord called upon me to verify, my lord, the government notification numbers. My lord, that I will file an affidavit along with the corrected number. My lord,
I recollected that it is perhaps heard.
Yes, yes.
8th.
Please, my lord.
Obliged.
This is number 32. Non-filing in contempt matters. Mr. Raghavendra C.
The complaint, please.
2 weeks time, I'm right. 2 weeks time and file a reply, mala. 3rd December.
Seal number 33.
For the complaint.
Had submitted on the last date, my lords, SLP is preferred. Post Deepavali, it might be listed, my lords, I
10th
requested.
December.
Great.
Seal number 34. The
That's
KV
it.
Narasimhan.
Lords,
For
in this
complaint.
matter, my lords, consider the representation for arrears of salary is the order passed by the learned single judge. Lords, the proposal has been sent to the finance department. Lordship may grant me 3 weeks' time, my lords, it's in the
Additional
process.
government advocate Srimati Pramodin Kishan stated that the proposal is forwarded to the finance department in pursuance of the compliance of the order. To stop. Keep rate for time, stand over to 11th December.
Obliged. Seal number 35.
So in this matter, we have filed our affidavit, my
Babu,
lords,
yes.
but it is listed as non-compliance. It's been complied and we
At the
have.
request of learned additional government advocate Srimati Pramodini Kishan, stand over to. When do you want? 16th December.
Lords, we have filed our affidavit, my lords.
You have filed affidavit.
Please, my lords.
Stated that she has filed affidavit. Stand over to 16th December.
Seal number 36.
Like for the complaint.
LM Chidanandaya.
The disobedience complaint of my lord, your lordship get page 22, my lord.
What do you want to file reply? Or it is filed?
Some time may be granted, my lords.
16th December. In order to enable learned additional government advocate to file reply.
Seal number 37. The ready in notice matters. Srimati Ashwini.
Appear for the petitioner in this case, my lord. This is a matter pertaining to the challenge to the agricultural marketing policy, my lord, of the state.
This can wait. 12th December.
My lord, the pleadings are complete, my lord. The matter needs to be
Still
heard.
it can wait. Yes, next.
Which date, my lord?
12th December.
Seal number 38. Srimati Shilpa Rani. Srimati Shilpa Rani. 38.
13th December. What is it about lying? It can go to stand over to, since learned, stand over to 18th December.
39 urgent, seal number 40, Umapati, yes.
14th December. You are there?
In this case, respond number 5 has filed the objection. State has not yet filed the objection. Respond number 5 has already filed a statement of objection.
So which-
1 to 4 state has to file the objection.
So we'll grant time. Time is granted to the
Leave
respondent.
objection not there.
to file their send over to 14th December.
Obliged.
Much up.
14. Number 41. Mr. Muniappa. 41.
Petitioner, madam. Senior counsel has been engaged. The senior counsel has been engaged. He's not in town. Short date, please.
11th December.
Obliged.
Seal number 42. Srimati Dimantika Gowda. Seal number 42.
December.
My lord, may I make one submission? My lord, the notice will have to go to respondent number 5. Mr. D. Nagraj appears for respondent number 5. My lord, the authority, State and Environment Impact Assessing Authority. He appears for them, my lord, respondent number 5. His name may be shown for respondent number 5.
When shall we keep?
My lord, it's only a writ of mandamus, my lord, to them. My lord may have it on
Send over
7th
to
of
26th of November. Name of learned advocate Mr. So and so shall be indicated on behalf of respondent 5.
obliged.
26th of December 43. Mr. Sharat. Srimati Sabahat Sultana.
Nobody is there. 5th December.
December 44. Mr. Pradeep HS.
Petitioner. This is a appeal to
Serial number 43, Empress.
Respondent 11 here, my lord.
But I don't think we've been served with papers.
Yeah, sir.
Respondent number 80.
8. We are served. Anyhow. We have already served.
You're not giving to us.
Any date? We have challenging the encroachment of the respondent number 11.
So you're discriminating, not giving to us and giving to your learned friends. Giving some Diwali gift. What do you want? Don't want to give anything to us. Be lighter. So serious. Why you're so serious?
I think.
Getting more serious. Yes, what is filing reply?
That's it. Maybe taken up after.
My lord, the authority who has to take action has been served, but it is not represented. The Kanakapura Planning Authority.
But this council is not speaking any.
The respondent number 5. The Kanakapura Planning Authority have only suspended his building license, but the encroachment is on the Raja Kalve. That has to be removed at Raja Kalve and Star Motor.
But you have given some reading material to.
Please.
Give us. You all know, will not give us that reading material. In view of the fact that counsel for the petitioner is too serious to be tolerated. Stand over to. You're too serious to be tolerated. Stand over to 4th December.
Obliged.
By then, Right, respondent number 5.
What he is saying, you ask him, we will speak to him.
Very long.
Really, really.
Thinking is not prepared. Have to file objections. He's not prepared his house. Seriously?
When you know, you know when the person goes speechless, in what circumstances? Either he is in deep shock or he is overjoyous. In both state of mind, you can't speak. So what is your state of mind? Yeah, what? We'll adjourn it, but implicitly. You're waiting for your senior counsel?
No, Your Honor. We are sought for direction against the respondent number 11 for encroachment of the Raja Kalvi.
Third December. December.
3rd December.
3rd December.
Number 55 to Vinayak B.
35.
Lord, this is the matter, my lord, pertaining to imposition of GST on royalty. My lord, so far,
GST on?
or royalty, my lord.
We'll take up after some time. 20th November.
Please.
Number 46. To Ravindra Gajanan Kulle.
Please, my lords.
Yes. Go to, give some date, after 15th.
Number 47. Mr. Ganpati Bhatt. Mr. Ganpati Bhatt.
You are requesting for time.
Pass over, my lord.
Pass on? Nah, we knew that, 21st.
Number 40,
21st.
48.
Pass over to 21st of November.
Number 48. To Shreyas Narasimha. 48.
Will not be over.
49. Mr. Chakki Siddhavir. 49. And 50. To Ravindra Gajanan Kulle.
That's 48, Manu.
48 is already gone and adjourned. To which date? It is
4th of
already
December. 4th of December.
4th of December. Next.
50. To Ravindra Gajanan Kulle. Number 51. Srimati
My lord,
Deepa
in serial, my lord, in serial number 51, I'm appearing for the petitioners, my lords.
Yes.
My lords, I seek for an adjournment, my lords.
All.
My lords, interim order may kindly be extended.
It will be extended.
Obliged.
25th November.
Great. In 51.1, there is an objection, my lord.
It's not early, not too long.
51.2, there's an office objection regarding some records. Respondents will have to resolve it.
Number 52. To Doreraj BN.
My lords, I
It's
appear for
appearing
the respondent number 1, Union of India. I submit that this a batch of identical matters are before the Supreme Court, my lords. This matter may be adjourned sine die, my lords.
My lords, they have matters that are before the Supreme Court, but my lords, this particular matter has not been clubbed with it.
Not club.
Not clubbed. My lords, I kindly seek for passover, my lords, senior will be here.
No, pass. 4th December.
Sorry, my lord?
4th December.
Lords, until the Supreme Court decides the matter, there actually will not lie much of a point, my lords, in troubling your lordships with this matter at each future date. It may be adjourned sine die, my lords.
Let it be on that day you may request on 4th.
Please, oblige, my lords.
53. To Deepak Bhaskar.
Because I appear in 53, 54, 55, all arising out of the same order. On the previous date, my lords were pleased to grant an interim stay of the impugned order. I'm led by senior advocate Mr. Fanindra, and if I could get a short accommodation.
26th November, interim orders shall continue till the next day.
Great.
56 urgent, number 57, Mr. TP Mutana. 57, Mr. TP Mutana. Number 58, state appeal. Number 58.
215 days.
15 days.
of delay. Who appears?
Notice have been issued on the delay application, my lord.
Nobody appeared.
Mr. Padmanabhar.
Let them come. 8th November.
Published.
Number 59, Mr. KK Vasan.
For the appellant, I made an application for stay off for the impugned order. I sought for stay of the impugned order, made an IA number 1 of 2024. I sought the copy on the government.
Who appears?
Mr. V.R. Balraj.
1 to 4 is the government and Mr. Balraj is 5 to 7.
Who issued notice? You issued.
Mudolda. That is order dated 28/5/2024 at page.
Order is passed is only of sending back the matter.
Lord, the order is sending back, my lord, the direction issue. But Lordship, my kindly see the direction to the extent of that they comply with the order and carry out to the so far to 40 in respect 4 acres, 4 guntas of land. Instead of 2 acres, 4 guntas of land. The total extent is given. Only re-grant was made only 2 acres, 4 guntas. They have claimed actually 4 acres, 2 guntas, and Tahsildar passed an order saying that is only available area is only 2 acres, 4 guntas. But learned single judge says that entire 4 acres. That is consideration at para 7. Two pieces of land is claimed by the respondent 5 to 7.
Lord learned advocate Mr. So-and-so, so-and-so for the appellant. Ordinal petitioners and learned additional government advocate Mr. Harish.
Respondent number 1
For the
to 4.
respondent state and its authority. The present appeal under section 4 of the Karnataka High Court Act 1964 is directed against judgment and order of learned single judge, whereby the writ petition was allowed and the following order was passed. And quote the order at page 42, impugned Segalekar order. full stop in the writ petition. What was prayed by the petitioner was to set aside order of respondent 4 as the Tehsildar, Yelahanka, Bangalore, passed in case number LND, interpreted NA, full stop CR, full stop 868, down 11-12. Undated order, undated order of the fourth respondent. By the side order, the application of the respondent petitioner, application of the petitioner, Srimati Kemapamma, for body and duress was directed to be considered as per the rules. In the event of the respondent applying for the same, only for 2 acres and 4 gutas in survey number 72, along with original records. The prayer of the respondent for the application of the respondent for body and duress in respect of 4 acres and 8 gutas was not exceeded to. It was further prayed in the petition paragraph to direct respondent 2 to 4 authorities to effect body and duress in respect of land in question, which is 4 acres and 8 gutas. First of all, as could be seen from the operative directions issued by learned single judge while imposing of the writ petition, learned single judge has, after quashing the order, demanded the case to respondent 4 plus approved orders afresh paragraph. And the order is only of remand. This court is not inclined to enter here with the same and exercise the appellate jurisdiction inasmuch as while the remand proceeding will be considered, the parties including the petitioner will have opportunity to submit the case on merits. It is our clarified that while deciding on remand, the respondent 4 shall consider, shall not be influenced by any observation made by learned single judge if touches on merit, and shall independently examine the case to pass a fresh order after hearing both the sides. No further order could be, no further relief could be granted. The appellant, the appeal is not entertained subject to above limited order. इसके पहले लिखो the competent authority may decide the proceedings on remand within 12 weeks from today. Shall decide the.
Please, my lord. In fact, in page 60, my lord, it is mentioned that they will consider only 2 acres for guntas.
59 is over. Next.
Number 60. The Padmanabha. Number 60.
Done.
Number 61. Vinay Kirti.
Appear for the complainant. They have to submit that their objection with respect to that, your lordship. The specific direction is that from this honorable court to consider my representation in the light of the.
Who will appear?
Mr. B.S. Srinivas.
Let it be on 26th of November. Chalo, next.
Number 62. To Shivram Bhatt. 62, Shivram Bhatt.
Last.
Now the government has filed a compliance report, which is not in accordance with the order passed by the division bench of this honorable court. My lord, kindly see the compliance report, my lord. Now they have given effect. The complainants are the retired teachers of the elementary school, my lord. They sought for the extension of the increment which was given to the government school teachers. Now, my lord, the prayer made in the writ petition, your lordship kindly see, my lord. In the earlier writ appeal, this honorable court has held, my lord, page number, annexure C, page number 25. Paragraph number 20, relevant paragraph number 20.
The direction not complied.
Direction, my lord, kindly see, my lord, that this is the earlier order passed by the division bench of this.
Earlier order will go later.
Yes.
Which are the directions not complied with?
Yes, my lord. Now, this order, my lord, the page number 17.
Council, you answer which are the directions not complied with.
Yes, my lord. Yes.
Page?
Yes. Page number 17.
17.
17.
So decide the representation.
Yes. My lord, order portion, my lord, page number
Date of
17.
judgment in writ
The
appeal
petitioner.
720. So where is the appeal, writ appeal 720?
That is at page number. It is at page number, my lord, 25. Operative portion of the order, my lord. Your lordship will get it. At the page number 46, paragraph number 21. The appeal is allowed in part to the aforesaid extent only by clarifying that benefit of stagnation increment from 5 to 8 shall be extended to these respondents with effect from 1/4/2012 and not as directed by the learned single judge from 1/4/1996. In all other aspect, order of the learned single judge is affirmed. Now, your lordship kindly see, my lord, I am entitled for the stagnation increment from 1/4/2012. Now the increment is given from 18/8/2023, compliance annexure R2, your lordship kindly see, my lord. Annexure R2. My lord, there is no benefit at all. If this order is given effect to, my lord, I have no benefit at all. 2012 onwards, I will have to get it.
So this page 46, the decision on accordance with page 46.
That was not complied. 2012 onwards, I am entitled for stagnation increment.
Take instructions in this matter.
Get instructions. He appears to be right. If he is right, he is right. When shall we?
After
Little-
10 days, Manoj.
Little longer.
Once, my colleague appears, Manoj, Shweta, 10 days, Manoj.
10 days time. 3rd December.
Yes. Yes.
Let him take it.
Yes.
Number 63, Mr. Vinay Kirti. 63. Number 64, 65 adjourned. Number 66, Mr. Kamlesh.
Appealing for the complaint. This order passed by this honorable court has not been complied, my lord, so far, even after lapse of nearly 2 years.
Lord's complaints has been filed, my lords. The copy was also served, my lords.
Even we have submitted a relevant document. Even my objection is also ready, my lord. They have not complied the order.
I have complied, my lords. The
Complied.
Complaints memo is also placed on record, my lords.
We have submitted document. What they say, we have not submitted document. We submitted a document more than thrice, my lord. We approached the authority more than 20.
You file your rejoinder. 4th December.
Number 67,
Please.
Mr. Rahul S. Reddy.
Complainant. May I request for an adjournment in this matter, my lords? My colleague Rahul is not present. May I request for an adjournment in this matter?
For December.
Obliged.
Number 68, SB Total.
For the complainant. That's it. It is with respect to promotion to the post of associate professor.
Awaiting service, 5th December.
Number 69, Mr. Praveen HP.
Because the compliance affidavit filed by the accused number 3, my lords, is not in accordance with the order passed by the lordship. I may draw my lord's attention to the order passed, my lords. May kindly see the writ petition order, my lord, at page 18 of their petition. Page 22 is the operative portion.
My lords, at page number 22, my lords, I may be permitted to read the first order. Short issue involved in this question is with regard to payment of compensation in respect of the land measuring 155 square meters, which was acquired with a preliminary notification. Plus, may I read? Preliminary notification dated 26/8/2021, followed by final notification 2/11/2021. My lords, apparently, my lords, this order has not been challenged, my lords, and has attained finality. Now, my lords, the affidavit filed, my lords, may kindly be seen. In 2021, my lords, 155 square meters was acquired. Now, if I may draw my lord's attention to page number 56 of the affidavit, my lords, which is filed by the accused number 3, my lords. Accused number 3, my lords, has filed the affidavit. My lords may kindly see page number 56. There, my lords, the compensation has been calculated, my lords, on 50 square meters, and that too, my lords, on 2015 rates. Whereas, my lords, the acquisition happened in 2021. In 2019, my lords, there was a revision of the amount, my lords, or amount of compensation, and no interest has been paid. My lords, may kindly see page number 56 of the affidavit, my lords.
What is it?
You can only see page 57. I've explained why. That additional, that land, my lords, we've written to KIDB saying it is, we don't require it, 1. So kindly denotify. 2, we've also written to the complainant saying we are utilizing only 51 additional square meters, for which we already deposited 1.36 crores. You are free to come and recover. Kindly see page 57 at page 58 and 59. We conducted a survey, my lords, which we refer to at paragraph 2. And at paragraphs 3 and 4, my lords, we page 58. You are further informed that it is now realized, page 58, my lords, of my affidavit.
Your reply.
Yes, my lords, our respondent number, sorry, accused number 3 is reply. My learned friend was referring to page 56, the very next page, my lords. Next page is the endorsement, page 57.
It pleases my lords, my only humble submission before this honorable court, my lords, is that now, my lords, the accused cannot come before this court and say, my lords, they have not utilized the land, that's why they cannot pay compensation. They have taken possession of the property from me. They have notified the same, my lords, and for that reason, I couldn't use it from so many periods. 2015 was the initial notification. 2021, they again acquired. They have taken possession of 155 square meters. Now, my lords, they are coming before this honorable court and saying, my lords, they have not utilized the land. That's why they are not liable to pay compensation.
Come on, fifth, sixth, sixth.
Sixth.
You.
In November.
If I may please. If I may please, your lordship, serial number 25, your lordships, I want the order of stay on the execution and operation of the learned single judge's order in commercial court, your lordships. However, I could not be present when the first time the matter was called. So kindly grant me an opportunity to hear the matter today, your lordships. I want an operation of which one? Serial number 25, your lordships. We are on an appeal here, your lordships, from the commercial court's order.
No, today not.
Your lordships, at least a shorter date if possible, your
Date
lordships.
is given. 26th November.
26th November, grateful.
Your lordship, one humble request, your lordship. Your lordship, R3 to R9 notices may be dispensed with, my lord. They're not.
Sir, Rudra Bhushan, sir.
My permission. List number 2 for pronouncement of judgment. Seal number 1, writ petition 7043 of 2021.
Petition 704.
Seal number 2.
1 of 23 and contempt 266 of 23. LP 17634 of 2022 dated 25/1/23 is hereby set aside. Respondent 1 liberty to initiate appropriate procedural fee and so on merits. In view of the pending as not survived. In view of order in writ appeal 361 of 23, contempt does not survive for consideration accordingly disposed.
Seal number 3, writ appeal 754 of 2024.
I appear for petition.
Connected with contempt 511 of 2024.
Appeal 754 of 2024 and connected matters. Writ appeal 754 of 2024, writ appeal 1014 of 2024 are allowed. The order of the learned single judge in WP 15590 of 21 and review petition 22 of 24, both dated 19/3/2024 are set aside. Writ petition 15590 of 21 is hereby dismissed. In view of order in writ appeal 154 of 2024, contempt would not lie.
Great for members.
List number 1, 230 matters. Seal number 102, 102, Mr. A.V. Gangadharappa for withdrawal.
I appear for the complaint, but I filed a memo seeking for the withdrawal of the contempt petition. Madam. The affidavit of the complaint is also produced along with the memo.
Learned advocate of the complainant invited attention of the court to the memo dated 14/10/24. Getting inter-alia that for the reason stated in the memo, the complainant is not inclined to prosecute the contempt petition further. In that view, Mr. is not pressed.
Number 103.
Why it is listed? Why it is listed? Who is listed? Without date. Please may put up the matter with appropriate submission.
Seal number 1.
Received by party today. In view of the email received, email stated to be received today by the petition, by the party in person.
Please, Your Lordship.
Seal number 104.
Not today, no time, we are not sitting. 12th.
Obliged. Number 105, Mr. Sharan Desai, party in person.
My lord, I am party in person, my lord. This matter is posted for orders.
You are not in Bangalore, Mr. Party in person?
My lord, I am in Bangalore, my lord. I could not appear before your lordship, my lord. My lord, this matter is pending 2018, my lord. The order is already been issued to demolish, clear all the illegal encroachment in the fort, my lord.
That the matter pertains to, my lord, the encroachment in the Gulbarga fort, my lord. Certain encroachments are there, my lord. My lord, now it is brought to our notice, my lord, the archaeological department, the concerned officer of the superintendent archaeological department of that circle has written a letter to the Archaeological Survey of India, my lord, to the head office, saying that, my lord, it cost about 37 crores, 82 lakhs and 40,000 for rehabilitation of this, my lord. We are awaiting the further communication from the the Archaeological Survey of India.
The present public interest petition came up for consideration today. The petitioner party in person appeared through video conferencing. Whereas learned additional Solicitor General Mr.
Shanti Bhush
stated that there has been a correspondence between the authorities of the archaeology department and that she will place the necessary facts on record before the next day. put up on 3rd December.
Please.
My lord, please, your lordship. Instead of 12th, can it be 13th or 14th?
Whenever, then 14th
14th,
or 13th, better 13th.
13th, much obliged.
Seal number 106, Mr. Naveed Ahmad.
I appear for third respondent. My lord. In this case, my lord, the grievance of the petitioner says that there are encroachments in the road of the Tipu Sultan Road, my lord. We have removed the encroachments and road has been widened. Now it is under use, my lord. The petition does not survive for consideration. I am appealing for the municipality third respondent.
You are saying that
Yes, my lord.
learned advocate Mr. So stated that this petition does not survive for any further consideration in view of the
In view of the removal of the encroachments and widening of the road.
view that
Tipu
the
Sultan Road.
grievance is, as the grievance itself does not survive.
Yes, my lord.
So dismissed accordingly. Learned advocate.